Does an owner have to have prior notice of a defect in order to be held personally responsible for your injuries? It depends. It depends on your status on the land, meaning what type of guest on the land are you? There are different requirements for each level. First, if you're a trespasser, the only duty that the landlord or that the owner of the property owes you is to make sure he doesn't go out of his way to injure you. The next level up is a social guest, or what they call a licensee. In that case, the owner of the property has to make sure that they notify you of any dangerous or defective conditions which exist on the property that the owner of the property knows about at the time you are a guest there. If the defect or the dangerous condition on the property is open or obvious to anybody, then the owner of the property is not charged with notifying you of it because the law says that it's so open and so obvious that you should have seen it yourself. Finally, the third and highest level of guest on the property is a business invitee. That's someone who is on the property for the benefit of the owner. And if you are, that's like being a customer in a store where you enter the property for the benefit of the owner who's selling you items. In that case, if you're on the property, the owner not only has to notify you of any dangerous or defective conditions on the property that they already know about, but they also have to take reasonable steps to periodically inspect the premises to make sure that there are no new defective or dangerous conditions that they hadn't previously known about. So if they didn't inspect and there was a danger that they didn't find, the court will say that they turned a blind eye to it, that they should have known about it, and then they'll still be liable.